The Supreme Court on Monday observed that while it was not in favor of a regulatory regime leading to censorship, online content platforms cannot be completely unsupervised. The court has in fact asked the centre to come up with a draft regulatory mechanism on social media content which should be put in public domain aside from gathering suggestions from all stakeholders. In fact, it was hearing a petition regarding obscene jokes by celebrity podcaster YouTuber Ranveer Allahbadia. In fact, the top court has also acknowledged that the matter may require closer scrutiny. We don't want any regulatory regime which is about censorship, but it also cannot be a free-for-all platform. That's what Justice Suryakant said. Meanwhile, Supreme Court has also allowed Ranveer Allahbadia to air his YouTube segment, The Ranveer Show, subject to maintaining morality and decency, and an undertaking that it was suitable for all ages. Allahbadia's remarks on parents and sex on comedian Samay Raina's show, India's Got Latent, had sparked a massive outrage and several FIRs were lodged against him. He is known as Beer Biceps. But what is the top court asking the centre to consider a draft law to regulate online content mean for content makers, the content industry, and also online platforms? That's what we will try and discuss tonight. Joining me now is Girish Vankade, who is an OTT analyst, somebody who tracks these trends very closely. We also have Pawan Rele, who is an advocate in the Supreme Court. Thank you so much for joining me on this broadcast. To you, Mr. Rele, first, Pawan, should digital industry brace itself for, substantial regulatory regimes or, in that sense, some kind of new laws? Because we had the broadcasting bill which was shelved. What more can you expect in the coming days with the Supreme Court itself asking the centre to consider a law in this regard?
See, first of all, I would like to tell you that how it has arisen actually. As we all know that on 18th of February, Allabadia has approached the court for clubbing off all the FIRs which are there in all parts of the country. There are so many parts of the country where the FIR has been lodged. And then also sought the history of the FIR, and then Honorable Supreme Court has imposed one condition that Allabadia will not record the show or will not conduct any show. Now, for that purpose, the matter was listed today that to remove that particular condition as a bail condition. And then when this matter was listed, as far as my knowledge is concerned, it was learned Tushar Mehta, learned SG, Solicitor General of India, who has told the court that Allabadia content in India Got Latent is not only vulgar, but it exhibited a sign of perversity. And it was this thought of Shri Tushar Mehta which was seconded by the Honorable Supreme Court. And then Honorable Supreme Court then emphasized the necessity of regulatory measures to prevent the digital media from broadcasting content that might violate moral and ethical standard. So I do not think that it may be the part of the order, because it was just a simpler application, simpliciter. But yes, the court has observed this.
These orders, do you see them as binding? Because for the government, it's actually better for the government to actually get an instruction from the court, is it? They also want laws, they also want to regulate YouTube. So although it may not be binding, the fact that the Supreme Court has said this is a good cover for the government to bring in more laws.
Certainly it is going to impact, and it also reflects the intent of the government to bring laws. Because if you see, there are hardly any laws, there are very limited laws actually which govern this field, and I would like to point out that. First is the IT Act, Information Technology Act, which came into picture in the year 2000. And then there is a second regulation called Information Technology Intermediary Guidelines and Digital Media Ethic Code 2021, which does not actually provide a kind of punishments neither to the intermediaries nor to the content creators. So there are very limited guidelines actually. Now, what today we are facing the situation in the country is that what will happen if someone is creating online content which is going to go against the morality and obscenity and decency. So there are hardly any rules. There are very limited rules, I think. For example, if I tell you, I have pointed out, there is only with section 79 of the Information Technology Act, which provides the punishment for publishing or transmitting obscene material in electronic form, and the punishment is very less. The punishment is, I think in first conviction is 3 years, and the second conviction it's 5 years. Okay. So there is no accountability and responsibility as such. If you even look at the IT Act and if you look at the Information Technology Ethic Code 2021, even the responsibility which is there for the social media intermediaries is only to that they will direct to remove the content.
Okay.
And then the content will be removed, and after that there are hardly any guidelines and hardly
Okay,
any,
so fair enough.
punishment.
Girish, you know, there is a view that says that there are laws, but there's no adequate punishment. But there are also laws like representation of indecent representation of women, or for that matter, there's also the IT rules, there's also the IT Act, and there's also the Bharatiya Nyaya Samhita. So a lot of people also feel that there's duplication when it comes to certain sections. But my question is, when it comes to subscriptions on platforms, I also believe that all content have a right to exist. If you censor YouTubers from India, YouTube will always show YouTubers from, say, the West. Isn't that being very subjective? How are you going to regulate a platform that does not know any borders?
Exactly. It is always difficult for the platforms to impose on the various regulations. But yes, it is more of a self-regulation for the OTT platforms. They have to come forward for the more stringent rules of age verification. Also, the content creators should be more responsible. They should be more aware of what they are going to offer, because at that point it has to balance between the creative freedom of the content creators as well as the morality or the social responsibility of the OTT platform. It has to be balanced somewhere. In that context, there will be rules, there will be regulations, but overall coming on the creative freedom, we need to have the trust which should be in between the platforms and the content creators. So I think this freedom which these people have taken it to such a worst extent is something which will happen only if there are no regulations.
Right. Mr. Rayleigh, you know, if you look at the Bombay High Court, which partially stayed IT rules 2021, and it cited grounds that free speech was being stifled. Of course, a lot of people have taken a refuge of that. But when you look at the legal hurdles a lot of these regulations have faced, there have been several. What kind of legal challenges do you foresee for any of these regulatory attempts that the government comes up with from the industry side?
See, generally, I'll tell you, see, it's not a debate which has risen now. This is a debate which has been going on since centuries. I'll tell you, there is a very famous debate called cyber regulation versus cyber libertarianism. Cyber regulation, people say that there has to be a regulation. Government says that there has to be regulation. And then cyber libertarianism, people says that once they go online, they should be completely free. They are not bound by the rules and regulations which are existing in a physical world. They should be treated differently. But if you ask those people that how do you get such right to speak anything or to express your opinion, anything, they will say that they have the freedom of fundamental right, freedom of speech and expression. So the time you point out that you have fundamental right of freedom of speech and expression, that is given under Article 19(1)(a), that's how the right is taken from, fundamental right is taken from. So the time we say, or they say that they have fundamental right of freedom of speech and expression under Article 19(1)(a), they are also bound by the reasonable restriction which is given under Article 19 Clause 2. And there are, I'll tell you, few reasonable restrictions which are given under Article 19 Clause 2. They are sovereignty and integrity of the state, security of the state, fundamental relation with the state, public order, and then there is a decency or morality. So if someone is challenging, certainly anyone can challenge any rule. That depends on that particular statute, and that depends on particular rules. Okay. But we have to see, the court has to satisfy itself that whether it is falling under the reasonable restrictions or not.
Okay.
And I believe that the contents which are being made nowadays, it is crossing all its limit, not only of the morality, not only of the obscenity, but also of the decency, because all three have a different dimensions to see. And okay, the time it is falling under morality or decency or obscenity, it is falling under the reasonable restrictions. So I don't see, that's what I told in the beginning, that the time learned SG also, I think, wanted to read the mind of the court with regard to this.
So everything is falling in place for more regulation is the sense that I'm getting. Girish, how do you see, as somebody who follows cinema very closely, OTT platforms, you've also seen a lot of new content come on YouTube, digital content, OTT media. Tell us, how is this going to impact creative freedom? Is there going to be self-censorship? Is there going to be more of self-regulation? Do you see this impacting the way artists work?
Yeah, it will definitely be a clue for the self-regulation, because there is certain responsibility which comes with your creative freedom. You create a web series, you create talent shows, you do everything. But if we see, every after 6 or 7 months, there is an uproar about something which goes derogatory, from Tandav to Maharani to any web series, or a lot of web series, and even this YouTube. So there will be always some artist who will try to misuse it, try to exploit the situation they are into, and there will be some responsible content creators. These are the more importantly, they are the prestigious production houses. But the newcomers who come into this medium, they want the shortcut to gain the popularity, and then they submit to these shortcuts where they use obscene language, or they turn to harmful content which could be derogatory for the minors. So such restrictions has to be very self-regulatory. There should be somebody, obviously, in spite of us always talking about prioritizing the freedom of speech, we will say that this freedom of speech comes with a special responsibility, and that responsibility comes on both the ways, from the OTT platforms as well as the content creators. So if that is the balance we are talking about, then it is favorable. And this regulation, this particular mandate, embargo, will definitely go away with all the content creators, and they will be more conscious in the future.
Right. Mr. Rele, my question to you, and also your closing remarks, when you talk about balancing creative freedom with responsible broadcasting, we're talking about private, personal content here, content that I see on my mobile phones. Isn't it unfair on the viewer? Because when one of the judges today said that humor is for the entire family to enjoy, sometimes I just want to watch my own content without any restrictions. Isn't that too much? Isn't that creating too much pressure on content makers to create content that is viral, that's liked by everybody, regardless of class or rural-urban divide, generations? I don't think there's any content that can, surpass these restrictions.
You very rightly said, and also very rightly said by my co-panelist, that see, when we talk about fundamental right of freedom of speech and expression, again, I will tell you, it is not an absolute fundamental right. It is subject to the reasonable restriction. Now, as you pointed out, that what will happen that if someone has subscribed to, or it's only a subscribed oriented members can watch that particular program. But if you notice, it is not happening. So what these YouTubers and these people are doing nowadays, that they make one big show of 1 hour that will be available to the members. But after that, there will be reels circulated to the entire media. That is not confined to those particular members actually who are entering into it. So even the people who have not taken the subscription of that particular thing,
right,
that particular membership, if they have not taken, then also they have to watch it. Then also they may watch it. Okay. Because see, while watching reels, we don't have we don't see that sometimes,
okay, so you often get content that you've not expected. That's a very valid point. Thank you, Mr. Rele. Thank you, Girish, for joining me on this very important broadcast.